Will not have that short note that we have given.
1 second. এখন গুছাই দিব না এটাই ফলে মিলে পাৰিব নি
Paragraph number 10 and 9 sorry, 10 and 11 আছে।
তুমি যোৱা Yes, Mr. Kalra, you want me to take what?
Lord, could the note for today be taken up? Today's note that we attended in the morning.
Note. Mr. Mr. Chester, you will have to organize the court's file after the hearing gets concluded because so much loose papers are being given. It becomes very difficult to, trace it. So the documents which the petitioner side has given and the documents which the respondent side have given, maybe, you can just separate them and we can just put a blinders tape then. Otherwise, it's getting a little confusing. This is the note, I think, today's note.
Indeed, it says rejoinder submissions, hearing dated 15/9/25 on the top.
You all have not given any written arguments, no? But you had given a note today. Where is that note? This one.
Regarding Vidas.
This one.
Yeah, it's regarding Vidas lordship. Okay.
You dice.
Yeah.
Yes, Mr. Kalra.
Yes, my lord, may have the first new ground. So the first part, as I said, talks about the new stand, the new defenses that the state has taken up for the first time in their counter, in their submissions, not in the counter affidavit. So my lord would just have 1A at page 1.
Yes, you have already taken me.
Yes, no, I want to show from the relevant pages also because that will really add on more strength to my argument that which is the relevant page supporting this submission.
Yes.
Like for the first one, my lord would see diploma certificate of the petitioners has a date beyond 1/4/19. A lot of arguments were made on this context by the
You
learned.
want me to see what page?
Yes, please come to the writ petition, my lord. Kindly see the Supreme Court order, which is at page 568.
So this is that A, the details are that ABC. This is what you are reading now.
Yes, I am reading ABC.
So the first is the diploma certificate of the petitioner has a date beyond 1/4/19.
Indeed.
What do you want to say here?
I want to show two things. One is the Honorable Supreme Court's order at 568 of the writ petition.
Yes, to what effect?
To the effect that it does not cast a date by which the certificate should have been obtained. There is
That's all right. I am not on that. Yes, next.
The second document for point number A is the second last page of the same very note. Please see one RTI that was obtained with respect to the same aspect.
But petitioners have given wrong information in the forms regarding working status.
No, 1 second. My lord, I am trying to say that for point A, there is another second supporting document for point A itself.
Yes.
Which is the second last page of this very note which my lords are having. Kindly have page 10 of the same very note.
Yes.
11 are the questions. Please see page 11. These are the questions put in an
No.
Yes. The questions my lord would see at page 10. Let us see the questions first. At page 10. Page 10 are the questions.
Yes.
The first question is 2017-19 NIOS
Page 10 of this note, Mr. Bakala.
Yes.
Page 10 doesn't have any, it has only one question.
Well, it has two. Descriptions of information sought, there are two. Is and does.
Is the requisitor below poverty line?
Well, below that, description of information sought. At page 10, what my lords were reading is requester below poverty line.
I think you are reading page 11.
No, my lord, what my lord was reading is requester below poverty line. Please go below that.
I think you are in page 11. Yes, come to page 11. Tell me. The last page, right?
No, first please see page 10.
Yes.
Below poverty line, there is some description mentioned. Just below that, the next very row.
Oh, is 2017-19 NIOS
D.el.ed batch.
d.el.ed batches course is completed by 31st March 2019 or not?
Yes, that's the first question.
Yes.
Then the second question is very, very relevant. Does the certificate issued on 22nd May 19 imply that a course was completed by 31st March 19 or 22nd May 19, although our last exam regarding NIOS D.el.ed was held on mid-March 19?
Okay.
Let us see
These are RTI questions.
Yes, these are the RTI questions to NIOS. Please see the answers at page 11. The fourth row is public authority NIOS, which is the authority which conducted.
Has Mr. Saikia argued anything on this?
Yes, my lord, there were a lot many dates shown.
Permission was given that regarding that holding of qualification before 1/4/2019.
Yes.
Please see the answer. The answer to the first question is yes.
Yes.
That every course was completed on before 31st March 19. The second answer is very important. NIOS conducted d.el.ed program for in-service untrained elementary teachers working in so-and-so as per directions of Ministry of Education and recognition by NCT. As per MOE and NCT guidelines, all the activities related to so-and-so have been completed by 31st March 19, including the final examinations.
Okay.
So this is the response to point number A. Let us please go back to the note now.
Yes.
Please see B now.
Yes.
Another aspect of fraud was claimed, saying that we had
wrong information.
wrong information.
Yes, because you said, are you still working? That one document was shown where it says no.
Yes. For that, the entire advertisement needs to be seen. That what was the real question put to me. Please have the advertisement at 574 of the writ petition.
Yes, you read.
Yeah, the relevant is 575. The question actually is, the regular teachers already working in lower primary schools under DESM are not allowed to apply in any post. That is the main point. So the advertisement says that if you are working in a lower primary school of the government run by the government of Assam, then you cannot apply.
So page
575.
All right.
So
understood.
This is an answer to that.
Okay.
Then please come, my lord, to the third point.
Yes, private school in the state are governed by the Assam non-government so and so. Yes.
Yes. The answer, there are a lot of, firstly, my lord, ground will have to be discarded because it does not form a part of the counter. This is not a stand taken in the counter anywhere. But, my lord, what is most important is those 6 documents, all 6 documents that a private school has to issue to a teacher working there is not mentioned, even in the act. Those 6 documents, I repeat, the school.
All right, noted. You don't have to repeat, noted. It is not mentioned there. Yes, next.
Then please come to 162, page 2. Page 2, article 162, ground D. This is another fresh ground taken by them.
Yes.
My lord would recall the impugn circular has nothing to say about 162.
Yes, you are citing those cases on this.
Yes.
All right. Does not specify that those are under 162.
Yes.
Okay, fine.
Now, my lord, this is another fresh ground which now they are taking up in the past 8 years for the first time, that they did not do any verification under the directions of MHRD.
Okay, this is that showing that coordinator and all that. It is only the names are given.
Indeed, my lord. This is contrary.
So what do you have to say to that?
There are 2 things. This is contrary to the records. It is contrary to the RTI given by them to us.
Where that question was verification and said yes.
Indeed. Third most important part, it is contrary to the directions given by MHRD to the state. I will just once again show those directions.
Just show me, give me the pages. I remember those. Please give me the page numbers.
Yes, very well. The page number, firstly, for the direction given by MHRD, is at 48 of the volume, second volume, CC. Convenience,
Second volume.
yes, convenience compilation, page
Okay, then
48. Page 48.
yes, then
Second thing is the RTI application, which is the second document in the last note. So there are two notes given by us, the first note and the second note.
that is not on record. It is only enclosed to your
With-
written note.
with the written note.
Yes, then
So these two things clearly show that the
that verification was done.
verification was done at by that time at that level. Then please come to ground F.
Yes, clubbing.
Clubbing, there is a direct judgment which I will just show now.
Yes,
Now the judgments I mentioned, Malone, all those judgment copies are ready.
yes.
But meanwhile, can we just skip this? Let us come to the next part. Judgment we'll take up at the end. It will be easier.
All right, all right.
Please come, my lord, to page 3 bottom.
Yes, no response.
Yes, to these averments or the allegations raised by me, there has been no response
But
today.
that you have already said. You have taken me on the last occasion that they have not given parawise response to all that.
My lord,
Very well
yeah,
noted.
these averments may be important. One, as I said, is RTI.
Yes.
They have not responded.
Very
Number-
well. Circular pertaining to UDICE and challenge verification. That's qua so and so.
Just,
Done.
just one
Okay.
thing I will take here, my lord. This UDICE point number B is very, very important. Kindly have, of the same very note which my lord is reading, these two circulars the government should have produced, but they have not done it. Please have page 7, page 8 and 9 of the same very note my lord is reading. Page 8 my lord may have.
Yes.
To show that UDICE is still not mandatory, please have the date on the top at page 8, 20th March 24.
Just 1 second. Mr. Chiste, that time I was trying to recall, I was supposed to ask you another thing.
Yes.
One paper was given to show that UDICE is required.
Yes.
Something was given.
So that was a 2012 NCT.
That's notification.
Yes. What is this? What does this notification say, Mr. Chiste? Let me just get the clarification from them so that I can appreciate your response then.
Very well, my lord. Very well.
Because I was having a doubt here.
Very well, my lord.
If my clarification is concerned, I will note it down because let my Mr. Advocate General approach because it will be better for.
That is okay. I can give you that. But only thing I wanted to understand
Yes.
this, because from this letter,
Yes.
we can show that UDICE is now compulsory because, of course, you have shown that in
Yes.
some schools they are having it. That is all right.
Yes.
But the fact that UDICE is required,
Yes.
you see, because if it is required, then they have to have it. If it is not required, then it is not necessary that a school which is legitimately and validly running
Yes.
will apply for it because you have not made it compulsory, right? So in that situation, to ask a petitioner or reject a petitioner for non giving the UDICE record would be absolutely arbitrary.
Yes.
But suppose what I have been made to understand is that the reason for asking UDICE is to ensure that schools are validly run.
Yes.
You see, the
Yes.
purpose is something else,
Yes.
right?
Yes. Yes.
There is a lot of thing there for having UDICE code and all that. So that to ensure that this particular teacher who is applied is having the UDICE code means that he is not some fraud.
Exactly.
So these are the things.
Yes.
But which is the document which says that in the state of Assam,
Yes.
all schools must have UDICE code? This is one which you need to show. Huh? According to you, the 2012 document does not say, right,
Does
Mr.
not say.
Kala?
It does not say, my lord. In fact, there are two circulars of the government to the contrary.
Those are at page?
Page 8 of my present note, which my lord is reading.
Page 8.
Page 8. Please see, this is Board of Secondary Education, Assam. This they should have brought in to say that we have not made it mandatory in the state. But what is most
All
important
right, Mr. Chester, you take note of these additional documents.
This is secondary education. Secondary education lawsuit will not require any UDICE lawsuit.
Acha.
Both
Mr.
secondary-
Kalra, the counter here that has been submitted, did you hear?
I heard, my lord, but answer is that
According to him, this is pertaining to the secondary education, and the case in hand is elementary, right?
lower.
Is elementary.
Please see page 9. Page 9 is the answer. Page 9 is for lower primary also.
Yes, serving from lower primary, upper primary, high school,
Everything.
higher secondary shall mandatorily have UDICE.
But the date of this is 2025. June 25, they are making it mandatory for the first time. And then also it is not mandatory. Please see the language. Wherefore it has come to the notice of the Department of
Anyway,
Social.
this is one aspect government has to clarify. You've understood why I'm asking. You see, because
Yes, yes.
I can understand the other conditions, but UDICE, which if you don't make it compulsory, then you see some school may not have it.
Yes.
Now, just because they don't have it, you can't make the teachers serving there suffer, right?
Yes, yes.
Yes.
This read with one other document that I had given was a flow chart of registration done in 2017. That when we registered in this NIOS portal,
Yes,
there
this
also-
let Mr. Chester take note of these three documents because they have been newly introduced, and let us see what they have to say, Mr. Kala, on
Very-
this point.
Yes.
Very well.
Yes.
Then please come to C, ground C at page 4. I have reread the counter once again, my lord of the state, which is ground C at page 4.
Yes.
There is absolutely no allegation qua my experience certificate.
This if you argued, yes, I have understood. You are saying that they have never, firstly, they've never disputed, correct? They have never questioned
Indeed.
your experience certificate.
Till
Yes.
date. Till date.
Yes, in fact, Mr. Saikya has fairly submitted also that is not their case. They are not saying that your experience certificate is manufactured or fabricated or they are disputing. That is
Right.
not their case. Correct, Mr. Chiston?
Yes.
You are not, that way you're not experiencing, but you want to verify to ensure
Yes, you are.
that what is there, because of the fact that an experience certificate can be, there are various ways and means that cannot be, which cannot also be ignored, ruled out
Yes.
in the context of the past few instances that has taken place here. Correct? I think that was the background.
One of the argument of Mr. Learned Advocate General was that they have mentioned that some schools were not in function post-COVID losses, but they have obtained the experience certificate in the year
That
2025.
is anyway, that is because
So
of
certificate.
see that is different.
Yes.
That they are saying in this petition.
Yes.
But the fact that you yourself is asking for these these certificates
Yes.
without saying that the experience certificates which these people have submitted is wrong.
Yes.
This is what Mr. Kalra is saying. He's saying that if you had doubted, if there was a doubt as regards the experience certificate, then to clarify that doubt, yes, you could have asked for additional documents. But when you are not having any doubt, or you do not doubt the veracity of that particular experience certificate given by that principal, you don't say that in Mr. A's case that school doesn't exist, or in Mr. B's case that principal there was no such person as a principal at any stage. These are not yours. This is what his argument.
Yes.
Correct, Mr. Kalra?
Indeed, my lord.
Okay.
I derived this argument from page 48 of the convenience compilation, the second volume. Because
Yes.
page 48 of the convenience compilation says, which is a direction by the MHRD, that to prove in service, because this is a course by MHRD, to prove in service, experience certificate is sufficient. That's very, very important.
That I have taken I remember that 2017.
2017 directive.
I remember. Yes.
And then, my lord, we are coming back to the note. I am just ensuring that in the next 15 minutes we'll be done, my lord. Ground D we can just ignore, we can skip. I have given the specific grounds that we have taken, but they have not replied to in their counter.
Very well.
I have raised those specific grounds just for convenience at one place. And then please see E also. Despite me taking a ground in the writ that they have said that because they are misuse in the entire country, even in the time of argument, they could not cite even a single instance of the misuse.
That's all right. You have said that. Yes.
Yes. And then please see F. Now, this is really the fulcrum or the heart of the matter. Please see F.
Yes.
In the counter, my lord, I have stated that there was a verification in the writ. I have stated there was a verification done. Now, state should have been fair and transparent, replying to my averment made in the writ that what was done in 2017. They are silent. They could have come and said that we do not do any verification in the counter. They have not done that. They could have come and said that we did the verification, but we did not find your names.
All right, noted. Next.
And then please see G. As I said, my lord, the conditions qua petitioners has been the same since 2019 after completing the course. It has not changed. In the previous recruitments for similarly placed petitioners like me, never such documents were asked for. Those in-service candidates and me, petitioners, is exactly on the same footing. Today, the Honorable Supreme Court has recognized what was in existence in 2007.
Okay. Next.
And then, my lord, J, I will show from those two judgments, my lord, which I am relying upon, that there is a expectation of reasonableness and predictableness in state's function. The one of the judgment of the Supreme Court, which I will say, which supports my ground J, is that a candidate should reasonably predict what can come in. Why do I say so? Just give me 1 minute on this. In 2017, when I was enrolling for the Government of India course, had I known that these 8 documents would be required, maybe some of us wouldn't have enrolled. I would have gone for a regular course of 24 months. So the mind that I had in 2017 when one of these documents were asked, the reasonableness in my mind was that for admission, when they're asking for one thing, later on they can ask for one thing, no problem, unless expanded by a judicial order.
Mr. Kalra,
Lord,
when you applied
Lord,
in 2017,
17,
you knew one thing,
Lord,
that you have to give the certificate of diploma of 24 months.
indeed, my Lord.
You knew this. However, because of a relaxation being given by the state,
Yes, my Lord.
in case you are, the 18 months comes in. 18 months comes in, right?
Lord.
And there also now, because of that MHRD notification, right?
Lord.
That in-service thing comes from the MHRD.
Yes.
Because
Lord.
of that, now if suppose you are an in-service teacher
Lord.
at that relevant point of time,
Lord.
then you can. So these
Lord.
you know.
Lord.
This you know, right?
I know very well.
Correct. Now tell me one thing.
Lord.
Has any of these things been changed?
Yes, my Lord.
What has been changed?
The
Because you
change,
see, Mr.
Lord.
Kalra, what the state is now doing is to ensure that you are in service. They're asking for certain documents. How can you say that because they want to ask that too in view of the clarification we given in the review, coupled with the fact that the MHRD also says as in service on such and such date,
Indeed.
asking for certain documents for verification. All right, they may have done verification. They may not trust that verification. They want to do re-verification. They are only asking for X, Y, A, B, C documents. I'm only asking, I'm on this right now. Whether those documents possible, not possible, for the time being, let us just leave it aside. Right?
There's two
And
answers.
then what is unreasonable here? Because the candidate knew that it is only, but yes, of course, if suppose a candidate was not in service at the relevant point of time, and because the documents doesn't say that a verification will be taken whereby all these documents will be asked, he took a chance, he has a legitimate expectation ki no, since I just have to get a certificate from a principal and that is sufficient. Now then, this court, this equity court will now not... You understand what I am trying to say?
Yeah. Lord, there are two answers to it.
I am with you as far as the other things are concerned right now.
I get your point, Lord.
But this, when you are trying to make an argument that, look, in 17, this is what, and now this, there, you see, there is no change.
Well, I'll explain what the change is. Just give
Yes,
me two.
yes, please.
Lord, please, I have not shown this page previously, but it is a part of the document. It will be relevant from myself to clarify this query of my Lord. Please have page 76 of the second volume, CC. Please have page 76 of the convenience compilation. My lord, this entire argument of the state that there is some relaxation is incorrect. I will establish that why that it is not a relaxation. It is the question of equivalence. They are two separate concepts. Please have page 76 for a minute, my lord.
Yes, I have it.
This is an advertisement issued by NIOS, National Institute of Open Schooling, my lord. My lord, that on the top.
Yes.
Then, my lord, would see on the left below the concerned politician's photograph, my lord, this course. This is for my course, the present course, my lord. This course is approved by NCT and MHRD. Anyone with this qualification can apply for job anywhere in India. Please mark this.
Yes.
This is prior to me taking the course.
Yes.
Then please see, my lord, the second part of this, the pointers that are there, my lord. Let us see, in fact, the first one also. Government of India has given an opportunity to all untrained elementary school teachers teaching in government aided and private schools to classes so and so to get d.el.ed by 31st March 2019. Second is very, very important. Course duration is only 2 years. Please mark this. No further extension will be given. Therefore, rush to get yourself enrolled immediately. On request of the teachers who could not apply earlier, the date has been extended and last date for enrolling is so
Mr.
and so.
Kalra, I have not understood what is this. This is on the request of many untrained in-service teachers who could not apply earlier. Final extension is being given for registration for diploma.
No, this is the advertisement by which this present course was conducted. This is from the newspaper. This is the Government of India's advertisement prior to the course starting. The course that we are concerned about, because it was a one-time course. This one-time course was conducted subsequent to this advertisement. This
No,
advertisement.
but on top it is said, no, you have started from the sentence which starts below the photograph, but next to the photograph there is one caption. Read the caption.
Last date of registration.
No, it says on the request of many. Read that.
Teachers who could not apply earlier, final extension is being given for registration of diploma in elementary education.
So that is what I think. This is some extension given.
But this is extension for the very same course. If my lord would see on the
Okay,
top.
but this is not but now this doesn't say about the that relaxation is regarding the 18 months we were talking.
Therefore, what I am coming to, my lord, the relaxation is a concept which the state government in its reply is trying to canvass. What I am trying to establish is this. Kindly bear with me for 60 seconds. At the time of taking this course,
Then you give the diploma, the 24 months.
Well, we have given
relaxation. You see, in other words, it would be a relaxation. Otherwise, where is that advertisement? Which page?
Yes, it says equivalent also, my lord. Please see the
advertisement.
Yes, very pertinent to us. Please see 574. 574, eligibility at 575 of the writ petition. It says equivalent.
574,
the advertisement starts. And the relevant at 575.
2-year diploma in elementary education by whatever name known.
Yes, this needs to be.
I don't see any equivalent written there.
Yes, I am just showing that. Please see.
No, but it should have been written here. Where are you reading equivalent from?
Equivalent come from, Lord, the Honorable Supreme Court judgment.
Coming from is different, Mr. Counsel. The advertisement, the essential qualification and experiences at page 575 is absolutely loud and clear. 2-year diploma in elementary education by whatever name known.
Yes.
This is what you either have this or now immediately let us go to that document which says this 18 months. Which is that document? Page?
Can I just show 620?
Then let's see that first. Page 18 months. Let me be very clear on this.
Yeah, let us see the recognition order.
Page 18. No, sorry. Which page is that? That 18
months? At
53
of
the second volume look.
53.
Is the 11 foot.
50.
What is most important is 54, my lord. Please see 54.
Yes, even Mr. Chiste also said 54 first,
Yes.
but before going to 54, let Mr. Kalra, would you mind placing this entire document once again?
Very well, my lord.
Just read it again.
Yeah, 53. It is a letter by MHRD to the NCT, dated 21st August 17.
That I can see, Mr. Kalra. Just read the letter. This is regarding.
This is
Start
regarding
from there.
training of untrained in-service elementary teachers in government, government aided, government, unaided private schools. An amendment to the section 23 of the RT Act to extend the period of such training to 31st March 2019 has been passed by the Parliament. In this regard, it has been decided that NIOS will be the singular organization responsible for conducting the online d.el.ed program through SWAYAM portal for all in-service untrained teachers. The tentative number of in-service untrained teachers at elementary level is 11 lakhs. That includes teachers working in government, government-aided and private unaided schools. However, the actual number may change. NIOS will be completing all academic activities related to the above training by 31st March 2019. To ensure the above training through NIOS, NCT is directed to provide following relaxations under Section 29 of the NCT Act. Number 1. Teachers who do not fulfill the minimum eligibility requirement for taking admission in d.el.ed program, that is so-and-so, in class 12, will have to join NIOS and reappear for the class 12 exam to achieve the minimum qualification. NCT shall allow such teachers to take provisional admission in d.el.ed program of NIOS, subject to them acquiring 50% marks in class 12 before completing the d.el.ed program of NIOS. This would facilitate such teachers to pursue both the courses concurrently. Then please see 2, my lord. The d.el.ed course will be from 3rd October 17 to 31st March 19. The duration of the course will be for 18 months. As the d.el.ed program is of 2-year duration, NCT shall allow subsuming of 6 months internship period within the duration of the proposed online course through the SWAYAM portal, as well as all the teachers are in service and are already teaching. That d.el.ed programs of 2-year duration is important. They are recognizing that fact. It is simply running parallel to the 18 months, saying that because they are already teaching, 6 months will be merged into 18 months. That's what they say. May I read once again?
Yes.
The d.el.ed course will be from 3rd October 17 to 31st March 19. The duration of the course will be for 18 months. As the d.el.ed program is of 2-year duration, NCT shall allow subsuming of 6 months internship period within the duration of proposed online course through the SWAYAM portal, as all the teachers are in service and are already teaching.
Yes.
And then 3 and 4 may not be important for today.
Yes.
The point that I am trying to make, if I can just put it in my words, my lord, the basis of the state arguing that I have got a relaxation by this, their own document of MHRD may not really be right for this reason, that a 24-month is not being reduced. 24 months has 18 months of teaching and 6 months of internship. Therefore, it becomes 24 months. The ratio that has been applied here is that instead of doing 18 plus 6, you do 18 within 6. Purpose is 2 things. One, there is a timeline. 31st March 19 has to be completed as per the Act. The second most important thing is that a regular d.el.ed course cannot be done online. Here it is an online course. A person who is already teaching does not need to get a job again to do that internship. So that purpose of the internship is teaching experience. So a person who is doing regular d.el.ed course will have to go and take a teaching experience.
So exceptional was made. An exception was made.
And therefore, my lord, this read with one line of the Honorable Supreme Court judgment is important, because that really is the crux of the entire matter, that we are not claiming any relaxation. Please see, my lord, in the same very volume, in the writ, my lord, will just see one page with me. I'm sorry, I'm taking through another page. Please see 620. Please see 620 of the writ petition with me.
620.
620. This is the Honorable Supreme Court's judgment.
Yes.
My lord would have the second line from top, as such any teacher at 620.
Yes.
As such any teacher who was in service as on 10th August 17 and who acquired the qualification of d.el.ed by way of 18 months program through NIOS prior to so and so is a valid diploma holder and at par with any other teacher who has completed the 2-year d.el.ed program. So therefore, what is being laid down, my lord, in my humble submission is equivalence. If it is the question of equivalence, my lord, what is not being sought from people who are equally treated as me, how can it be sought from me is really my argument. I understand if I was claiming some benefit. This is
Yes.
not a benefit in my humble submission that I am trying to claim. My basic grounds in the writ is 14, Article 14, that a person who has done a regular course, a 24-month course, none of these documents are sought. I do a course as per Government of India's advertisement. Government of India says that yes, boss, if you want to do the course, you please give me one document, which is the principal's in service certificate. I give it. Today also I am ready to give it. Now the change from 2017 till 16th June 25. No document, no court order, or no communication says that apart from what was asked from 2007, more than 17, we will ask now. Till 16 June 25, no one asked. 17 June, which the include circular, where for the first time, after 8 years, I am asked for. So this is really the change in game.
All right.
And
Now, Mr. Kalra, just please point out another thing. Which page do I find the main judgment from which that review culminated?
the main judgment, unfortunately, is not on record. We will produce it, Malon.
Please, Mr. Deb, please kindly give me
Yeah,
a
Jaydeep
copy
Singh
of
will
that.
produce it.
Because you see, what happened is that after hearing, and when we go back, we start processing it. So at that time, I was trying to figure out these papers, and I'm not getting them. So because that judgment, also this court would like to have a look. So you just give a copy, please.
In all fairness, I must also state, my lord, that when my lord are reading, my lord, it would be easier to read from the clarification orders for this reasons that whatever was said in the main judgment because of the clarification order.
Kalra,
I mean, just as
please now don't.
no. My lord, it'll just be very confusing. It'll be very confusing. That is the point that I'm trying to make.
Dictate this court as how this court
absolutely
is
no.
going to apply this court's mind.
No,
I
I'm
shall
sorry.
read whatever I think is deemed necessary to do proper justice in this case.
No, that is not the
Yes.
intent. The
Anyway,
point, yes, that is
no
not.
offense taken, Mr. Kalra. On the lighter note, I said it. Yes.
Then, so I was coming back to the grounds, my lord. We were on the note that I was taking up the ground and how things have changed. That ground, my lord, would just have my note, the final note that we had given. So I was on the fact.
The note.
The note, the today's note, my lord.
Yes.
So when I say that justification of selecting, so why was insert? I'm sorry. We were at page 5, my lord.
Yes.
Page 5 of my note. At ground J. J was the one that we were last reading, my lord. That what is the basis of the justification of selecting these 6 plus 3, 9 documents? Specifically, when I have argued that these 6 plus 3, most of these documents are not mandated by law.
Yes. That you have
Yes.
very elaborately taken this court on the last occasion. Noted. Point noted. Yes.
And then the last part is those judgments, my lord. Can I just take my lord through those judgments?
Yes.
And then we'll be done, my lord. Kindly, my lord, have the first.
Yes, Mr. Dave, you be there. He'll come to you.
My lord would have the first judgment. which is regarding the representation of state authority, that state of UP and Whirlpool. Can I just show the relevant paragraphs directly?
Which one are you showing first?
First is state of UP,
Versus Muhammad Nu.
Mohammed Noor,
Para 1011. Representation, na?
representation. I am going a step ahead to say that even if there was a statutory remedy provided under the Act, which in the present case is not, still, may I read para 10?
Yes, yes.
Para 10 of this judgment says, in the next place, it must be borne in mind that there is no rule with regard to certiorari as there is with mandamus. So this is the present, it is a certiorari, that it will lie only if there is no other equal effective remedy. It is well established that that provided the requisite grounds exist, certiorari will lie although a right of appeal has been conferred by the statute. The fact that the aggrieved party has another and adequate remedy may be taken into consideration by the Superior Court in arriving at a conclusion as to whether it should.
Mr. Kalra, this you are trying to say, the fact that I think this court had put a query that whether you filed any representation before approaching.
Indeed.
On that you are saying these, that no representation is required.
Indeed.
Okay.
Only on that point. Whirlpool is also on the same line, Marad. I will not.
For representation, it's all right. I have noted. The other point, which one is that?
Then please see
Till Whirlpool, I think it is also the next case is on representation, I think.
that also we can leave, Marad. Can I just show one thing in Whirlpool, Marad? Please see.
That's okay. That's all right, Mr. Kalra.
Very well.
This
very
court
well.
may not go into that aspect.
Very well, Marad. I will directly.
As only on that point.
Very
However,
well.
you see, there is one issue which this court will certainly examine, because individually how one is affected, that has not been given. I don't know what consequence it will follow, but this is there in the mind of the court.
There
So
is-
I'm only expressing to that effect. If you have anything in these three judgments, you can show.
Yes.
But not about representing and coming, because not filing representation, this court will not issue a certiorari. That is not required. I'm not going to go into that.
Very well, Lord. Directly on this point, what my Lord asked, kindly have the last judgment, which is
Annamanda.
Nahesh Sridhar.
Annam
Huh?
Adinarana.
Which one?
Annam Adinarana.
Andhra Pradesh High Court judgment.
Huh?
Andhra Pradesh High Court judgment.
Andhra Pradesh.
Please have para 21.
Just 1 second. I'm not being able to locate that judgment.
Sorry.
They are all apex courts.
So the last judgment.
Last one is API Court, Lord.
My lord, the last one, which my lord is holding.
This.
Yeah, the last one, my lord.
Oh, there is one more.
Yeah, at the back of the page, my lord.
Yes.
My lord, you can sample. Yeah.
Yes.
My Lord would have para 21.
Yes.
The legal position that now may be summarized, an application under 226 of the Constitution of India is a proceeding in a court of civil jurisdiction. The provisions of Order 1 and 2 can be invoked as far as they can be made applicable to the proceedings in a writ application under so and so. Ordinarily, two or more persons cannot join in a single petition to enforce the separate claims, but very, very important, where the right to relief arises from the same act or transaction and there is a common question of law.
This is settled law.
So, my Lord,
Nobody is questioning about the joinder of parties in that context. Now, the thing is that specific grievances have not been canvassed before the court. In that context, clubbing of cause of actions have been said. This is the argument.
the answer is this, my Lord. Can I just
Otherwise, of course, if you have a common grievance, there is no bar in jointly coming. That is also different. But anyway, yes.
Can I just make an attempt to answer this? The specific or the common grievance of all the petitioners, 171 plus the new applicant that have come in, is rejection or possible rejection from a
The apprehension that it will be rejected.
apprehension from a recruitment on the basis of a notification, which is ultra virus the constitution and ultra virus the judgments.
All right. Very well.
That is the common submission in my humble.
Very well. Noted.
Then my lord would have. So we are done with the last one. Kindly have the representation also we may not look into again. Please see introducing new documents to prove eligibility. Kindly have, my lord, this is a very recent judgment, my lord, of the Honorable Supreme.
Yes.
It's called Tej Prakash Pathak.
See, there is no quarrel to that proposition that once the eligibility criteria is set
Right.
and an advertisement is issued, selection has started, people have appeared, then you cannot change that criteria. I don't think there can be any quarrel.
Lord.
Now, here there is definitely no quarrel, but the situation is like, but you see, all these propositions have to ultimately be tested in the context of each case, right?
Indeed, my lord.
So first and foremost, this court has to examine is that whether this impugned circular is introducing a new eligibility condition, or it is merely asking for some more documents to just re-verify. You see, these are the two, because if the answer to the first question is yes, then no way, immediately it will be struck off, because there cannot be a change of the game, as you have as you've been emphasizing since your first day of arguments. But I think that would be the issue.
Oh, very well. My lord, let me just
So now in Tej Prakash, what was the context? It here some which is that paragraph from where you can see what is the eligibility condition that has been changed.
Please
What
see
change?
para 20.4. If I can just rephrase my argument, my lord. The point
Page 20. Let us see this
Yes.
first, since you are placing a judgment of the apex court. Let us see the context,
yes,
because judgments of apex court are contextual.
indeed, my lord.
Correct, Mr.
Indeed.
Kalra?
Indeed, my lord.
Yes. 20?
Kindly have 20.4.
No, 24 point. Okay. No,
20.
that is not the facts. Where are the facts of this
The
case?
facts, my lord, would kindly see.
What is the facts? In what context this has been stated? Held. Sorry.
The facts, my lord, of the reference, because this is a constitution bench, can be seen at para 13.
Tara?
13, 1-3. This is the.
One second.
Sorry.
You read paragraph 5 onwards.
Indeed, my lord. 4 can also be seen, in fact.
Yes, very well.
Yes.
From 4.
At the relevant time, the Rajasthan High Court Staff Service Rules so and so, framed by the Chief Justice of the High Court under Article 229(2) of the Constitution of India, govern the appointments. Under the 2002 rules, the Chief Justice of the High Court, by office order dated so and so inter alia, specified the qualifications as well as method of recruitment for the post of translator, ordinary scale, in the following terms. We can just skip this, my lord. Kindly come to para 6.
No, don't skip anything. Read.
Very well. Translators.
You don't want to read what the court wants to.
No.
Huh?
I'm sorry, my lord, that is the
Yes, read.
more than what is required. Translators ordinary scale. Recruitment to the post of translators ordinary scale shall be made on the recommendation of a committee nominated by the appointing authority on the criteria of selection from amongst the graduate upper division clerks or officials in equivalent or above grade but below the grade of translators ordinary scale, with Hindi or English literature as one of the optional subject in graduation or lower divisional clerks, with Hindi or English literature as subject in the post graduation and having minimum experience of 5 years.
Hindi and English. Okay.
Hindi and English.
Then
Competitive examination.
competitive examination.
But
Okay, that part you can skip. Now come down to paragraph 6 later.
Later, while office order dated so and so, amendments were made in the office order dated so and so, thereby substituting the provision relating to the recruitment of translators ordinary scale by the following. Translators recruitment shall be made from the amongst the judicial assistants or junior judicial assistants having experience of 3 years by holding a test in English and Hindi translation. Candidates shall be given passages in English from judgments and records and shall be asked to translate them into Hindi. Similarly, passages in Hindi from the records or from some other books, etc., shall be
That
given.
is okay. The issue comes here. Minimum qualification, you see, shall be graduate, right?
Yes,
Preference shall be given to a law graduate. Now come to paragraph 7.
yes. Minimum qualification shall be postgraduate in English
So
literature.
there I think is the change.
Is the change.
Subsequent amendment, right?
Indeed.
Instead of graduate, now they want postgraduate in English.
Indeed.
Then come para 8 on 19, examination was held. 21 so and so appeared, declared, and then so and so. Then para 9, some of the answers file writ petition. Questioning the decision of the High Court in fixing the cutoff date on the ground that it amounted to changing the rules. Where did the cutoff date come from?
Cutoff date, my lord, would be seen from the date
Oh,
of.
in here only. This was so because the Chief Justice of the High Court ordered that only those candidates who secured a minimum of 75% mark will be selected to fill up the post in question. As only 3 candidates could secure a minimum of 75%, the list of so and so. So it is in this context, yes,
Yes.
because there was no minimum of 75 marks cutoff earlier. So that means the entire eligibility conditions have been changed.
Please see 7 also, my lord, with me for a minute.
I've understood in this context the ratio. You have to appreciate the context, correct?
Yes. I will make myself good, my lord. Just give me 1 more minute on
Yes,
this.
please.
Make myself good. The point that I'm trying to make is this. I'll just show 1 more paragraph of this judgment. In 2017, the eligibility to get the course in question was 1 certificate, 1 document. If the other documents were not available with a person applying in 2017, he was out. He couldn't have applied.
No. From where do you say in 17 it is 1 document? Because the advertisement doesn't talk about document.
Yes. Please see that. Let us see that once again. Please come to the
advertisement doesn't say document. Does the advertisement say that experience certificate from the principal in support of the 18 months? Advertisement doesn't say that.
My basis is on the point where I had done the course today.
That's okay.
Today, because
that's okay. Mr. Kalra, we are only appreciating this particular point and not the others. As far as this point of yours, which you are arguing, is concerned, where in the advertisement it has been said that only this document, because you are saying by asking the additional documents, now you have changed the the eligibility condition.
So
this
the
is your argument.
Advertisement not of the recruitment.
Correct.
Advertisement of me taking the course.
That is different.
No,
You see,
can
these
I
are
just
two,
explain this?
no, Mr. Kalra, these are 2 different situations. Now, here the history as why this in-service was necessitated. This was necessitated because some documents were also placed on the other date where it has been observed that some teachers are not having the requisite diplomas. And in order to ensure that either you obtain these diplomas or otherwise a failure to obtain, you shall be removed. I think that document is also there. You please give me the page numbers of all these documents which you had, which Mr. Saikya on the last occasion has referred. These are the documents, because unless and until the history of why this 2017, the advertisement, it has to be correlated.
Yes.
Then only finally this court can apply its mind and understand in what context and decide. Otherwise, it becomes difficult. Because simply by going by this, it will look like as if there has been some change. In 17, this is not asked. But 17 is for a different purpose, as I am understanding. So,
Well,
we
let's
should
kindly have that
document.
document. I must clear this impression because this is really the heart of the matter. There is no
Yes.
such document. There is no such document on record till date which speaks to what the learner state tried to argue, if at all. Rather, the document speaks in my favor. At the cost of repetition, have that page 47 with me for a minute.
Read.
It says, and this is a directive issued by MHRD, the Government of India, to each state. The direction says, for teachers in private schools, a certificate from the principal would be taken to ensure that the teacher is serving in the school.
Yes, but this is in the context of that 2017 process in service to opt to
Just
do.
Just one more thing, my lord. These certificates will be collected by the state. Very, very important. Why are we missing upon? Why is the government trying to miss upon this fact? One, this is not a request, this is a directive. Very, very important.
All right, noted.
Plus, my lord, it is the state coordinators which will enter the database. So I am trying to say today, because of the impugned circular, there is a change in the game qua this 2017 directive.
Noted.
And the judgment that, my lord, we were just reading, just see one paragraph in this context.
Yes.
Viewer, my lord, kindly come to page 24. Para 24.
Yes. Yes, read.
The principle of fairness in action requires that public authorities be held accountable for their representations. Please see the next line. Good administrations require public authorities to act in a predictable manner. Very, very important. And honor the promises made or practices established unless there is a good reason to not to do so.
Very well.
I'll pause here for 30 seconds, my lord. One, predictable manner in the present context would be that whatever was sought in 17, please ask again. Second part, if it does not have to be predictable, then what is the exception? The exception is there is good reason not to do so. Now, what is the reason here? Only one averment in the counter which says there are multiple cases where fraud is being committed. Let them show one real-time example. Not even after me pushing the last time till date, there is no one real-time example. So therefore, my lord, and please see para 26 also, the next in the same very judgment.
Yes.
Doctrine of legitimate expectation, my second ground. The doctrine of legitimate expectation does not impede or hinder the power of the public authorities to lay down a policy or withdraw it. The public authority has the discretion to exercise the full range of choices available within the executive power. The public authority often has to take into consideration diverse factors concerned so and so. The courts are generally cautious in interfering with the bona fide decision of a public authority which denies legitimate expectation. What really needs to be tested, my lord? Was there a legitimate expectation by the petitioners herein that when people similarly like me have been recruited without any of these documents? In 2021, they have been recruited by the state of Assam. 23, they have been recruited by the state of Assam. This course is done by NIOS. There is state-run course also by SCERT. Those are also for in-service teachers. There also they are recruiting similarly placed people like me in service without asking for these documents. So 3 instances of legitimate expectation that is built for me. I hope I am able to make myself clear.
Yes.
And then, my lord, similarly, there is another Honorable Supreme Court on similar ground, which is Sivananda.
Which one?
Sivananda, my lord. Kindly have the next judgment, Sivananda CT. On legitimate expectation. The first one was reasonableness. The other one is on legitimate expectation.
Which one?
Sivananda CT, my lord. This is by the Honorable Supreme Court, my lord. Sivananda CT versus High Court of Kerala. Para 17 of this.
1 second. This is Apex code, right?
Apex code, my lord.
And what is the citation?
No, the citation is, if SEC, my lords are seeing, will be 2024 3 SEC 812.
2024?
2024, my lord. I could give the AR one also for my lord's convenience.
2024 SSC Online Supreme Court 3184.
Indeed. Sivananda CT versus High Court of Kerala.
My lord,
No, this is Rajasthan.
my lord, it's 2024 TSCC
799.
799. Lord.
5-judge bench.
I
Constitution.
am not getting it.
My lord, we can refer to my book.
No, you just pull it out from here. These are the
My lord,
copies that you have given. Just pull it out from here. We have a blinder script depot multiply.
Just one more judgment and I'll be done, my lord.
Which is the other one so that he can pull it out also that.
The other one, my lord, is Dolly Chanda.
That I think I have seen. Dolly is there. That did you get the other one?
Yes, ma'am. Both of them.
If my lord would have the SCC copy, I could just read the gist to save time, or else I'll take my lord through each and every paragraph of this. This is a very important one.
Shivananda city question.
Would my lord
Yes.
have SCC copy?
Yes, yes.
Just see page 800 then, please. Page 800 of the SCC copy may be seen. The
Page
800.
800.
Yes.
What is the paragraph number?
My lord, this is the gist given in the beginning.
Now you're going to refer to the head note.
My lord, I can read each and there are 10 paragraphs.
No, I don't want head notes, please.
Very well.
This
Let
code
us see.
doesn't look
Very
at
well,
the
very well.
notes.
Let us please see
Give me the paragraph.
Very well, my lord. Let us please see para 617 onwards then.
Yes.
The concept of legitimate expectation is mentioned a lot in para 17.
Yes.
Another important aspect that rises for our consideration in these batch of petitions is whether the High Court's decision frustrates the legitimate expectation of the petitioners. Article 233 of the Constitution provides that the appointment of persons to be posted as district judges in any state shall be made by the governor of the state in consultation with the High Court exercising jurisdiction in relation to such state. Further, Article 235 vests with the High Court the control over district courts, including the posting and promotion of district judges. The maintenance of efficiency of judicial administration is entirely within the control and jurisdiction of the High Court. The governor, in consultation with the High Court, prescribes rules laying down the method of appointment and the necessary eligibility criteria for selection of suitable candidates for the post of district judges. According to 1961 rules, the High Court of Kerala was designated as the appointing authority and tasked with the responsibility of conducting the written examination and the viva voice. The actions of the High Court in pursuance of its public duty would give rise to the legitimate expectation that the process of selection of candidates will be fair and non-arbitrary. Then please see para 18. Doctrine of legitimate expectation under common law. The basis of doctrine of legitimate expectation in public law is founded on the principle of fairness and non-arbitrariness in the government dealings with individuals. It recognizes that a public authority promises or past conduct, this is very, very important, my lord, promise or past conduct will give rise to legitimate expectation. I will pause there for a minute. When I say past conduct, my lord, how has the state of Assam recruited similarly based individuals like me is important.
What is the context in which this has been done? What happened in the facts of this case?
The facts here, my lord, would kindly come. Please
No,
see.
you say it. You must have read the whole judgment. What is the facts of this
What has
case?
happened is that
Yes.
pursuant to the original notification coming out, the state of Kerala, my lord,
Yes.
presented the scheme for Kerala High Court Judicial Service Examination. The scheme was later amended, my lord. The original things that were required are mentioned at para 4. And then it was amended via subsequent notification at para 5.
Original is mentioned at para 4.
Indeed, my lord. 1, 2, 3, 4, 5 at para 4.
So these are not document.
No, my lord. It is here. This judgment is relevant for the doctrine of legitimate expectation.
Understood, but you said the original I thought I heard the word document.
Scheme. I'm sorry, my lord. I stand correct. I
Mr.
mentioned.
Counsels, please be careful when you say the words because this court has been noticing sometime you say something but it is not there. I understand your intention is not that, but you see, the moment you said document, I different.
No, my lord, I'm sorry. That is the. I mentioned scheme. What they wanted is at para 4. These are the
Yeah.
5 that were required. And then at para 5, it was subsequently changed.
5 is changed.
Yes.
So what is this change now?
The change.
Provides for the mode of selection. 5 stipulates competitive examination. So the marks and everything has been changed.
It has been changed, my lord. It has been modified.
Okay. Yes, okay.
Then my lord would kindly come to para 28.
Yes.
That the past conduct of the concerned authority is very, very important. That how have they dealt with similarly placed individuals at a previous stage.
At 28.
28. The substantive legitimate expectation.
Yes.
May I read, Lord?
Yes.
R versus North and East Devon Health Authority X so and so, the Court of Appeal laid down the test of abuse of power to determine whether a public authority can resile from a prima facie legitimate expectation. It was held that the frustration of a substantive legitimate expectation, very, very important, by public authorities would be unfair and amount to abuse of power. Importantly, it was held that the abuse of power constitutes a ground for the court to exercise judicial review of executive actions. I will pause there for a minute. As I said, Malot, this example I had cited in the beginning, that in 2017, when I was enrolling for this course, if any authority would have asked me for 10 documents, I had an option at that time that if I had those 10 documents, I will enroll for the course. If I don't have those 10 documents, I will go for the regular d.el.ed. Why would I enroll for the course? I had that option at that time. The fact that none of those 10 documents were asked from me in 2017 when I was enrolling, there was a legitimate expectation, read with the advertisement which I showed, brought into me, which said that I can apply anywhere in the country. The advertisement of the government of India, my lord, in 2017 says I can apply to anywhere in the country. It also says that my course would be treated as a 2-year course. The advertisement records that. So therefore, my lord, those are the two factors by which my legitimate expectation of being treated at par with a regular d.el.ed course is built in 2017. It is built, it is exercised in the subsequent recruitments. As I said, this is the third recruitment after my course being completed. The first recruitment was in 21, the other was in 22, 23. The present recruitment is the third one. So in both those recruitments, nothing was asked for.
Okay.
And then Malot, Dolly Malot have seen.
Yes.
So therefore, Malot, my humble.
I hope you're giving the citations to the other side as well.
Yeah, Malot, the note has it. We've tendered the note, Malot, and the note has all those citations.
Okay.
In fact, the paragraphs are also mentioned in the note.
Very well.
So, Malot, with these, it is I request, Malot, to kindly consider and test, if possible, Malot, test it on both these aspects. That one, is there a power to ask for these documents? Second, can they be made mandatory in nature? One, my lord would also want me to consider Dolly, read Dolly for a minute, or would my lord seen it?
Mr. Counsel, you were asking me the test, so I was just writing it.
Oh, very well. So the test, I will take my lord through Dolly also.
I'm just writing that.
Yes.
I'm not stopping you from placing judgments.
Grateful.
I'm only taking a note of your submission.
First is, my lord, whether the state has the power or the
Yes, I heard you. Let me write now. Now you've made me forget. The first you said power, and then the second is what? What is the second test?
Mandatoriness. Can they be mandatory in nature?
Yes, now come. You want to show something from
Wanted to show Dolly, my lord.
Dolly Chanda?
Dolly Chanda.
Yes.
This is also, my lord,
Para
on
7.
7, my lord. 7 and 8.
Yes.
May I read 7?
Yes, yes.
The general rule is that while applying for any course or study, my lord, course or study, we're not about recruitment, or a post, a person must possess the eligibility qualification on the last date fixed for such purpose, either in the admission brochure or in the application form, as the case may be. I want to pause here for a minute, Lord. This goes beyond recruitment. It says that if you have to apply for a course, as on the last date of the application, which I just read was some October 17, you should possess the documents as mentioned in the brochure by that time. So, as on October 17, which was the last date to apply for the present course, I should have had the document which was required in the.
All right, all right.
And then let us please see further. As the case may be, unless there is an express provision to the contrary, there is no express provision to the contrary in the present case, there is no caveat in any of these documentation that later we can verify your in service by asking you 10 more documents. None of that. That is no one's case. There can be no relaxation in this regard. That is, in the matter of holding the requisite eligibility qualification by the date fixed. Now, what is the date fixed is the question that I put to myself. Last date of applying for the course in 2017. This has to be established by producing the necessary certificates, degrees, or mark sheets. Similarly, in order to avail the benefit of reservation or weightage, etc., the necessary certificates have to be produced. These are documents in the nature of proof of holding of a particular qualification or percentage of marks secured or entitlement to benefit of reservation. Depending upon the facts of a case, there can be some relaxation in the matter of submission of proof, and it will not be proper to apply any rigid principle. That's very, very important. Rigid principle as it pertains in the domain of procedure. Right, 30 seconds, I'll pause here, my lord.
It's all right.
Ultimately, what we are today on, my lord, is a procedure that should have been done in 2017. I am not shying away to say that if 2017 these things were asked for me, I wouldn't have given it. Maybe things would have been different.
All right.
And then para 8 also, my lord. There's one more paragraph in this. I am reading the last line of 7. Every infraction of the rule relating to submission of proof need not necessarily result in rejection of a candidature. The last line of 7. Every infraction of a rule relating to submission of proof need not necessarily result in rejection of candidature. And then C8.
Yes, read.
Yes, the principle was explained in and applied in so and so. The controversy here related to admission to a postgraduate course in medicine. The relevant rule provided for addition of 10% marks if a candidate possesses diploma in the relevant subject of or subspecialty, and this benefit could be given only if the candidate's success in the diploma course was brought to the knowledge of the selection committee. The prospectus provided that the attested copies of the statements of marks and other documents should be extracted with every application. 3 such candidates were given admission who had not attached the certificate of having passed the diploma along with their applications. Their admission to postgraduate was set aside by the High Court on the ground that their applications wherein they have claimed the benefit of diploma were liable to be rejected as the requisite certificates had not been attached. This court, the Honorable Supreme Court says, this court, speaking through Justice Krishna Iyer, reversed the judgment of the High Court and held that the admission to the candidates had rightly been given as they had in fact passed the diploma before the date fixed. The relevant parts are produced here. So therefore, what they are trying to ultimately establish here is, or to speak in this judgment, is that even though the certificates so-called were not attached, but it was ultimately reversed by the Honorable Supreme Court, saying that whether they have done the course, whether they were in service in the present context, I'm trying to draw a line. And then finally at para 9, my lord, the appellant undoubtedly belonged to the reserved MI category. She comes from a very humble background. Her father was only a Naik in the armed forces. This is relevant to the facts of the case. They hold in favor of the proposition that I'm trying to canvass. So therefore, my lord, in all these submissions, my lord, and I am grateful for the patient hearing all throughout, my lord. Deeply grateful, in fact. My lord, may kindly consider on 2 aspects, my lord, of course, and setting aside the improved notification, if not, my lord, then not having it as a mandatory nature, if possible, my lord, on those 3 aspects. As I said, the first part of the improved notification, the second and the third. The first part has the most important part is a UDI score. The second, of course, is the diploma, etc., which all of us have. That's not really.
1 second. So, which are those three? One is UDIs.
But there were three parts. The first is to prove in service, which
Yes.
are six documents, my lord.
Yes.
Out of the six, one is UDIs,
Huh.
which is the most problematic, which is not even mandatory till today.
Yes.
Then one is the school management committee.
Minutes.
All right.
And the third is those payslip, salary statements, basic DA, etc. These are the six documents.
Okay. Noted.
And meanwhile, my lord, in my humble submission, unfortunately, my lord, of course, the interim minister, we were having the writ may be not rendered infructuous, my lord may consider till such time the judgment is pronounced, not some protection may be granted. So the
Don't
writ is-
worry. If you're before an equitable court, this court will do. If I'm wrong, if this court finds that a wrong has been done to the petitioner, this court will set it right.
Right.
Yes, Mr. Chiste, I'll need that clarification.
Regarding UDIs,
UDIs.
from where need to make.
Yes, number one.
Number
And also for the school managing, because I remember it, this was shown, but does this say about under this act, is there any, I think there was having to, it was mandatory for the schools to have a school managing committee, correct? Which is that provision? No, you take a note of
Yes,
it. Ms. Chutia, just keep a note of all this. When would Mr. Laika give these clarifications?
Lordship, sir, this week I think he will not be possible. Lordship, Monday next.
That is going to be too
Too
long.
long.
I would have. I don't want to keep it for because you see, then I will forget. Everything is fresh. I just wanted the clarification on the UDIS.
Yes.
And under which provision, if you can give it also, it's only on that because you see, you don't have a right to reply to a reply argument, right?
Yes.
But after hearing all the arguments, there are certain clarifications which the court is now asking from the state. Number one, whether UDIS has been made mandatory in the state of Assam. If yes, from which state? Number one. Number two, under the provisions of this act, where it has been laid down that these schools, government, government aided, unaided, private, should also have a school, mandatorily have a school managing committee.
Yes.
My lord,
I think it is there.
It's there in the act itself.
I am sure. Mr. Gogoi, you know that section.
2006, yeah.
Huh?
Then see on the basis of that particular provisions, one OMR also issued by the government.
Correct. Which is that provision? You want which book? This court will give you the book. You say which book you want. I want to see that provision.
in fact, if I can just be permitted, the impugned certain notification says minutes of school management committee to appoint me. So they will.
I understand. You see, for that, first of all, there has to be school managing committee.
Indeed.
Now, suppose that there is no provision for a school to have a managing committee. Where is the question of having the minutes?
Indeed, my lord.
Correct.
Indeed, my lord. I'm so grateful.
Excuse me for a minute.
20.
Hmm?
21.
21. This is 2009. Yes, right. This is the section which I had in my mind. Now, as per this, so therefore, Mr. Gogoi, this court wants some help from you. Please come forward. As per this provision, only all these schools, private schools, are now having
Yes,
the
yes.
school managing committee, correct? Say DPS,
All.
isn't it? Now, what is the meaning of a government aided school?
Government school lordship, the fund was supplied, provided by the government lordship.
So that is not purely a private school.
Lordship,
I-
lordship.
It may be
CI concept, earlier occasion, college also lordship, government aided was there lordship.
an unaided.
And it was,
So that is private.
private lordship.
So why is it written private, government aided, and unaided? So there are specific meaning ascribed to these
Private
three-
private is completely
private.
private. And private, in respect of lordship, societies, schools are private schools, societies were treated as a private school lordship. And unaided school is a somehow government connection is there lordship.
All right,
Aided
all right.
school is lordship.
So, but there is no fund.
No fund.
No fund.
Aided school is lordship directly provided the fund by the government lordship.
Okay. And government aided is where the fund is, it is funded by the government.
Lordship, lordship.
Okay. All right.
Just one last thing before I end, my lord.
Yes, yes.
Just sorry, my lord. Just one last thing. My lord, in the advertisement, my lord had put this question to me, therefore I am answering, my lord. In
Yes.
the advertisement of the present recruitment, the advertisement relies upon another circular of 29/11/23. I will show that. There it is mentioned that we are eligible to participate. There is no bar on us. It specifically
Yeah,
says,
which page?
Lord, that circular is not on record, but I will show that. Kindly have page 575 for a minute. This is a government document, my lord. If my lord would permit, only then would we produce it. Otherwise, my lord, it refers to. Kindly have page
I
575 of my writ, my lord.
yes.
My lord would see point 15.
Yes.
It says eligibility criteria for lower primary schools as per government in Department of School Education notification number dated 29/11/23. Now this notification para 20, my lord. I will produce this notification. It is not on record, my lord. This is a government notification.
Where is Mr. Chistek on? Yes.
Can I just read para 20 of this notification?
Mr. Chistek, also have this notification place it before the court next time. The notification which is mentioned in your advertisement
25.
at page 575. That is 29/11/2023. It's there in that clause 15 that it is mentioned. Just I want to see the entire notification.
Para 20
So
of
when
the
can we have it?
Friday notice.
Friday? Sure.
Friday, so
All right.
I just
And
from-
please give a note.
Yes, I've
Huh?
given everything.
Indicating those page
Yes.
page numbers and
Yes.
all. All right. Yes. Good.
I'm so deeply grateful, my lord.
So I'm as for you see, it is understood that arguments are all completed. It is only clarification from the state government on that UDICE and that initially from where that that 2 years thing, that particular page.
Relaxation.
Yes, relaxation, exception,
Yes.
and what was the other word? Equivalent,
Equivalent.
whatever be it.
Yes. Yes, that's it.
All right. So Friday, huh?
Yes.
My lord, last time my lord had only requested the other side that they will not do anything till Friday, my lord. The same request, if possible, my lord, may be made. The writ petition may not be rendered infructuous because they are
All right.
courts, my lord.
We good?
Very well, my lord. Grateful, my lord. Deeply grateful.
On hearing matter is there lordship after
Fine.
clarification lordship.
Okay.
Can we fix it in my
After-
All right. Give a date.
After
That last matter.
last matter.
Okay.
Grateful, my lord. Deeply grateful.